Hello, everyone, and welcome to Uncivil Law. For today's case, we have a case that is really just super special. It is the case of Jorge Baez-Sanchez versus William Barr, the Attorney General of the United States. In this case, Mr. Sanchez, who is a citizen of Mexico, is removable because he's a citizen of Mexico. But what happened in the case is what's really interesting. The Board of Immigration Appeals, which heard his case, um, lost an appeal. And how they handled the appeal does not please the Seventh Circuit Court of Appeals. So we're going to read the entirety of this case. It's relatively short. It's only 6 pages. And it just is so good because this is from Judge Easterbrook, who is a venerable appeal court judge. You know, of all the people to irritate, Judge Easterbrook is probably one of my least favorite people to irritate. So let's get started with this. This is just a wonderful story of a bureaucracy gone wrong.
It is definitely jam-packed with spice.
Oh, so much spice. So much spice. Jorge Baez-Sanchez, a citizen of Mexico, is removable as a criminal alien. His conviction for aggravated battery on a police officer renders him inadmissible by law. He applied to the Department of Homeland Security for a U visa, which would have allowed him to remain in the United States. The U visa is available to some admissible aliens who have been victims of crime in this country.
And to give a little bit of background on the U visa, so that is to allow non-residents to stay in the U.S. if they have been a victim of a particularly serious crime, or their immediate family member has been a victim of a crime. Say, like, if their family member got, like, murdered or something, they would be allowed to stay in the country, cooperate with law enforcement, and take part in the justice process. So in order to get that visa, you have to show that you were either a victim or an immediate family member was a victim, and you need to stay in the country in order to serve the broader idea of justice.
Yeah, absolutely. I believe it's also available for witnesses to criminal activity. So if they're witnesses, they can stay on the U visa. I think we covered that in a prior stream. Baez-Sanchez asked the immigration judge assigned to his case to grant him a waiver of inadmissibility, which will allow the Department of Homeland Security to rule favorably on his visa application. A statute permits the Attorney General to waive an alien's inadmissibility. Exercising that authority, an immigration judge twice granted the request for a waiver. After the initial grant, the Board of Immigration Appeals remanded with instructions to consider additional issues. The immigration judge did so and reaffirmed the decision. So here, this person was disqualified. They're petitioning to be undisqualified, and the petition's being granted. The Board of Immigration Appeals is sending it back for further decisions. No problem there. The lower court, the immigration judge, is saying, okay, I've taken this additionally into consideration, reaching the same decision. So far, so good. Let's carry on. On appeal to the board, the Department of Homeland Security contended the immigration judge erred in finding that Baez-Sanchez had shown the extraordinary circumstances needed to justify a waiver and had abused her discretion in light of Baez-Sanchez's criminal history and other negative equities. The board did not address either contention. Instead, relying on matter of con, the board concluded that the power to waive inadmissibility belongs to the Attorney General alone and may not be exercised by immigration judges. Okay, all this so far, so good. These are just textbook legal arguments. You know, two issues potentially from the Board of Immigration Judges they recognize. First issue is we think this is abuse of discretion. We think you have not considered the facts. You are outside the bounds of your authority. Perfectly normal kind of legal determination, right? Not a typical determination, but a perfectly normal one. And said, oh, by the way, we don't think you had authority to do it in any case because we think it's only for the Attorney General and not for you. Okay, both these are potentially valid legal issues. You know, no major problems so far. Let's carry on. On petition for review, we, the Court of Appeals, held that the regulation permits immigration judges to exercise all of the Attorney General's powers except for those expressly reserved by some other regulation. No other regulation withdraws from immigration judges the powers under the statute, which means that the board erred. Okay, very simple legal determination to a very simple legal issue. There is a code of federal regulations. It is the things published by each agency that further extends the law, further clarifies the law. And it is law. It's subordinate to the statute. So the statute beats the CFR, but the CFR is law. And it can be changed by the agencies, but it's law as long as it's on the books. And what the Court of Appeals said is, okay, we've got a provision in the CFR that says immigration judges can exercise any power of the Attorney General except for some reserved. This isn't one of those reserved powers. It's not taken away anywhere else. Therefore, it's something they can do. Now, note this leaves in question like the abuse of power issue, but at least it's something that is possible. So let's carry on. Because the Board of Appeals had not properly addressed any other question, principles of administrative law meant that we could not do so either. And perfectly normal in the federal system. In the federal system, you have to exhaust all the administrative remedies before you can move on. So if the board below didn't consider certain issues, that means the court can't consider certain issues. Now, of course, you can send it back to consider those issues, but you can't consider anything that wasn't considered below because you need to exhaust remedies. And of course, if they ultimately choose not to do something, you can deal something about that, but you have to send it back. Perfectly normal. We remanded with instructions to consider two possibilities that the Attorney General had raised in defense to the board's decision. First, that some statute, regulation, or organizational plan transferred to the Secretary the Attorney General's power to waive inadmissibility. Second, the power to waive inadmissibility may only be exercised in favor of aliens who apply outside the United States. We added that the board also, or perhaps instead, could decide whether to exercise in favor of or against Baez-Sanchez, whatever discretion the Attorney General possesses. So there's a couple potential issues we're looking at here, because this involves the Department of Homeland Security, which is, at least in some senses, distinct from the Department of Justice or distinct from the Attorney General. So there's two potential issues we want you to consider on the issue below. We want you to consider first whether or not some regulation, statute, or reorganizational whatever transferred some authority from the Attorney General to the Secretary of Homeland Security, because maybe this is his ball now. The statute says one thing, but maybe there's some other stuff somewhere that moves stuff around. And so we should read one for the other. Okay, potentially possible. And secondly, that you actually have to be out of the United States. So, you can do this, but you can only do it for people who are outside the United States, not within the United States, right? Go consider these issues for us in the first instance. We're remanding it for you to consider some other stuff you didn't consider. Get back to us. So far, so good. But now is where we go completely off the rails. What happens next beggars belief. The Board of Immigration Appeals wrote, on the basis of a footnote in a letter the Attorney General issued after our opinion, that our decision is incorrect. Wow, that's just great. So an administrative agency is writing that the court is just wrong. Their decision is wrong. I didn't know they could do that. Near to the Court of Appeals. Let's press on.
It sounds like they're like, first they asked Mummy, and then she said no, and then they went and asked Dad, and the Dad said yes, and they're like, well, Dad said yes. Me like, wait a second.
Yeah, a little bit like that. Instead of addressing the issues we specified, so instead of doing anything we asked you to do, the board repeated a theme of a prior decision that the Secretary had the sole power to issue these visas and therefore should have the sole power to decide whether to waive inadmissibility. That those two things do not necessarily follow. They don't necessarily follow. Yeah, the two different people can have authority to do two different things. So yes, the Homeland Security is the one that decides whether or not to issue the visas, but the person's disqualified. So who's the person who can make them qualify? It makes total logical sense to me as the Attorney General. They're usually the one that has the authority to do this kind of stuff, like to make qualified people otherwise they're disqualified and so forth. So if that's the Attorney General's power, makes total sense to me. So that's doesn't a conclusion that doesn't fall to my mind. The board did not rely on any statute, regulation, or reorganization plan transferring the waiver power under the statute from the Attorney General to the Secretary. Now, who needs such pesky things as statutes, regulations, or reorganization plans? Who needs such pesky things? Nor did the board discuss whether only aliens outside the United States may apply for relief. Likewise, the board did not consider whether Baez-Sanchez is entitled to a favorable exercise of whatever discretion the Attorney General remains. In sum, the board flatly refused to implement our decision. Baez-Sanchez has filed a second petition for review. So the Court of Appeals interpreted the law and sent it back. And the Board of Immigration Appeals said, no, we don't feel like doing any of those things. You got the law wrong, so we're just not going to do any of those things. We're just going to ignore you. Wow. That's just super great.
There's this wonderful thing that if the courts get it wrong, you can appeal.
Yes. We have never before encountered defiance of a remand order, and we hope to never see it again. Members of the board must count themselves lucky that Baez-Sanchez has not asked us to hold them in contempt with all the consequences that possibility entails. I'm not quite sure why the court just didn't do it sua sponte, because I'm pretty sure they can. Says like, well, you should be grateful they didn't ask, but I'm pretty sure you could have just done it. But maybe like the threat was enough, I guess.
Well, isn't this why in civil lawsuits at the end you say, you know, I'm asking for this, that, the other thing, and whatever other relief the court deems, you know, just and necessary. Yeah.
Yeah. That's one of the many reasons that you put in that sentence. It's the last sentence of every lawsuit ever. Yeah, it's the last sentence of every lawsuit ever. So I guess they decide not to take that option, but okay. The board seems to think that we've issued an advisory opinion, which incidentally is something a court cannot do. Like literally, they can't do advisory opinions. It's unconstitutional. They can only hear cases and controversies. The federal courts don't do advisory opinions ever. So if it's from the court, it's not advisory, just FYI. And faced with the conflict between our views and those of the Attorney General, it should follow the latter. Yet it should not be necessary to remind the board, all of whom members are lawyers, that the judicial power under Article 3 of the Constitution is one to make conclusive decisions not subject to disapproval or revision by another branch of government. We acted under a statutory grant of authority to review the board's decision. Once we reached a conclusion, both the Constitution and the statute require the board to implement it. This is not an option. A judicial decision does not require the executive branch to abandon its views about what the law provides, for the doctrine of offensive non-mutual issue preclusion does not apply to the United States. The Attorney General, the Secretary, and the Board are free to maintain, in some other case, that our decision is mistaken, though it has been followed elsewhere. But they're not free to disregard our mandate in the very case we're making the decision. That much, at least, is well established, not only in Plant, but also in other cases. The Solicitor General did not ask the Supreme Court to review our decision, and the Department of Justice is bound by it. The Attorney General's brief in this court does not defend the board's decision, but neither does it confess error. Instead, it asks us to remand, so the board may address in an authoritative decision whether the immigration judge may adjudicate an application for a non-immigrant waiver under the U.S. Code in removal proceedings. The request is bizarre. We've already held that immigration judges do possess the power if the Attorney General himself retains it. We directed the board to consider whether the power had been transferred by statute, regulation, or reorganization plan to the Secretary of Homeland Security. The board chose not to address that question, and we're hardly going to remand it so the board can write another opinion about whether we erred in construing the statute. The Court of Appeals is not pleased. That's water under the bridge. The Attorney General contends that a new decision by the board could be entitled to deference under Kisor v. Wilkie, but we held the regulation is unambiguous. An agency is entitled to reinterpretation of an ambiguous regulation. See, for example, National Cable Telecommunications Association versus Brand X Internet Services. Well, gee, where has my channel ever heard me talk about Brand X before? Ha ha ha. But cannot rewrite an unambiguous one through the guise of interpretation. Changes require rulemaking. So even though Brand X normally allows an agency to reinterpret stuff on the fly, not in this particular case. So let's move on. The only remaining question is what should happen next. After concluding an administrative decision is flawed, a court of appeals normally must remand to the agency. Yet we've already remanded, only to be met by obduciary Obduciary. What the fuck is that?
I don't know, but I want douchiary to be a word.
Obduracy.
Obduracy? Maybe it's from like...
Unmoved by persuasion, pity, or tender feeling. Stubborn, unyielding. Stubbornly resistant to moral influence. Persistently impenitent. An obdurate sinner. How do you pronounce it?
Sounds like it might be similar to obstinate.
Obstinate, yeah.
You're...
Obduracy. Obduracy. Okay, great. I'm on board now. Fine. Well, I'm going to redo that sentence. Yet we have remanded only to be met by obduracy. The remand rule is designed to afford the agency an opportunity to have a say on the issue, a say that may reflect expertise and could be entitled to judicial deference. The board had that opportunity and disdained it. Another reprimand would do little besides give the board a free pass for its effrontery while delaying an alien's entitlement to a final decision. That's not the goal of the remand rule. Baez-Sanchez has waited long enough. We deem all the legal questions settled. For the purposes of this proceeding at least, the Attorney General retains his power to grant waivers of inadmissibility, and immigration judges may exercise that power on the Attorney General's behalf. An immigration judge has ruled in favor of Baez-Sanchez. If the Department of Justice were contending the immigration judge had abused her discretion, then we would remand it to the board to address the subject. But the Attorney General's brief in this court does not ask for a remand on the propriety of granting a waiver to Baez-Sanchez in particular. The brief the Department of Homeland Security submitted to the board on remand similarly does not contend that immigration judge erred if immigration judges possess the waiver power. All the issues in this proceedings therefore have been finally resolved, and there's nothing more for the board to do. The petition for review is granted, and the board's decision is vacated. That leaves the immigration judge's decision in force. The executive branch must honor that decision, which grants Baez-Sanchez a waiver of inadmissibility so that he may seek a U visa from the Department of Homeland Security. So that is the end of the case of Jorge Baez-Sanchez versus William Barr. In this case, we learned that Jorge Baez-Sanchez was convicted of various crimes, which would normally render him ineligible to remain in the United States and subject to mandatory deportation. However, there is a law that allows the Attorney General to grant a waiver, and a code in the Code of Federal Regulations that allows an immigration judge to do it. An immigration judge did do it, and this issue got appealed to the Court of Appeals, who sent it back for some further findings regarding some stuff. And then the Board of Immigration Appeals, which is a board within the Immigration Authority of Homeland Security, decided to just ignore the Seventh Circuit. So the Seventh Circuit said, okay, then, never mind. This guy now has a waiver. It exists now. So, you can decide whether or not to grant the U visa because the Attorney General has granted it. We're not sending this back for further decision. We're just telling you what's happening now. This is what's happening now. Please stop ignoring us. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.